Good morning, fellow Ghanaians. This morning, two matters have dominated the national conversation. Two stories that at first glance may appear separate, but when carefully examined, reveal the same underlying test of our democracy. Whether we will respect our constitution, our institutions, our processes, or whether we'll allow politics, propaganda, and opportunism to distort the truth and poison the civic space. The first is the removal of the Chief Justice, Gertrude Araba Isaba Saki Tokuno, after the committee constituted under Article 146 of the Constitution completed its work and submitted its findings to the President. The second is the Akwatia by-election, triggered by the sad passing of Ernest Yakumi, the Member of Parliament for that constituency. These two developments, though seemingly different, converge on the same lesson, that democracy only works when we allow due process to run its course, when we respect the rules we have agreed upon, and when we resist the temptation to weaponize lies and distortions for partisan gain. Fellow Ghanaians, let us begin with the matter of the Chief Justice. Fellow Ghanaians, there has been so much noise, so much fuss, and so much cries of illegitimacy and conspiracy. The one would think the President woke up one morning, scribbled a dismissal letter, and unilaterally sacked the head of the judiciary. Nothing could be further from the truth. The reality is that every single step taken on this matter has been firmly rooted in our Constitution, specifically Article 146, which prescribes the only lawful path by which a Chief Justice or any superior court judge may be removed. The President did not create the petitions against Madam Tokuno. He received them as required by law under Article 146(3 as is explicit. And when the President receives such a petition, he must consult the Council of State and determine whether there is a prima facie case. That was done. Before making that determination, he was constitutionally required to seek the views of the Chief Justice herself. That too was done. And once a prima facie case was established, the President was required to appoint a committee to investigate. That committee, chaired by a Justice of the Supreme Court and composed of others as stipulated by the Constitution, was duly constituted. The Constitution also gives the President authority under Article 146(10)(a) to suspend the Chief Justice while the investigation is ongoing. He exercised that authority, not out of malice, not out of vendetta, but out of duty. The committee then proceeded with its work, affording the Chief Justice her right to be heard and affording her the right to counsel, conducting proceedings that some have said respected the fundamental principles of fairness and natural justice. At the end of this process, the committee found her guilty of stated misbehavior and has recommended her removal. The President, according to the Constitution, is bound by the recommendation, the findings of this committee. So tell me, where is the irregularity? Where is the unconstitutional shortcut? Where is the overreach? This is not the first time Article 146 has been invoked. Loretta Lamte, the former head of SHRAJ, was removed under the very same provisions. Charlotte Osei, the former chairperson of the EC, was removed through the same process. In fact, under an NPP administration led by erstwhile President Akufo-Addo. Were those removals unconstitutional? Were they acts of tyranny? At that time, many of the loud voices crying wolf today cheered those decisions and proclaimed the Constitution was working. Several High Court judges caught on their NAS investigative tape that judicial corruption investigation were all removed under this very same Article 146. Did anyone say then that the process was illegitimate? What we are witnessing today is selective outrage. It's political opportunism. It is the cynical weaponization of constitutional illiteracy to score partisan political points. But the facts are plain. The process was followed to the letter. The Constitution was not abused, it was applied. This is how a democracy functions. Allegations are tested, rights are respected, committees investigate, and findings are made, and then consequences follow. That is not persecution, that is constitutionalism. Fellow Ghanaians, our democracy cannot survive if you only respect the Constitution when it produces outcomes we like and denounce it as illegitimate when it produces outcomes we dislike. If we do that, then the Constitution becomes a tool of convenience, not a covenant of citizenship. That path only leads to chaos, and we must reject that. If you want change, the Constitution, we may do so. But to claim the process is faulty just because it involves someone we like is plainly wrong. So that is it for the Chief Justice. Now let's turn our attention to Akotia. Today, the people of Akotia go to the polls to elect a new representative in Parliament following the death of Ernest Kumi. We must begin by hoping and indeed demanding that what happened at Ablekuma North during the rerun election does not repeat itself in Akotia. The violence, the chaos, the intimidation we saw then was a stain on our democracy. Elections are supposed to be a contest of ideas, contest of persuasion, not contest of machetes and bullets. Let the people of Akotia vote in peace and let the outcome reflect their free will. That is the essence of democracy. But even before the ballot has been cast, the by-election has already been marred by gimmicks and disingenuous claims. The government machinery has already been thrown into frenzy and rage. Roads are suddenly being leveled. A new DVLA office has been launched with pomp and pageantry. Projects that could not be delivered for years are suddenly being rushed because of a by-election. Fellow Ghanaians, is this how governance should work? That our communities must wait for death to strike and by-elections called before they see development? That roads must only be fixed when a seat is at stake? That offices must only be open when votes are on the line? This is not development. That is vote buying with taxpayer resources. It is cynical, it is insulting, and it must stop. But even more worrying, however, is the conduct of former Vice President Dr. Mahmoud Bawumia, who went to campaign in the constituency for the NPP candidate. In his remarks, he sought to suggest that the NDC bore responsibility for the death of the late MP, Ernest Kumi, because he challenged his election in court, a litigation that supposedly, according to Dr. Bawumia, put pressure on the late MP. Fellow Ghanaians, this again is disingenuous. It is false. And it's not something that someone considered a statesman who once held the second highest office of the land should be peddling. Let us recall the facts. Dr. Bawumia himself was the second petitioner in the 2012 presidential election petition. In fact, he was a star witness for the NPP, testifying for days, cross-examined for hours, all in a bid to return or overturn an election result through the lawful process of the court. Was that wrong? Was that illegitimate? Was that an act of persecution? Of course not. It was the lawful exercise of a democratic right. And even more striking, under the administration in which Dr. Bawumia served as vice president, the NDC MP for Assin North, James Jachekwesi, was dragged through the courts in a manner far more severe than Ernest Kumi ever endured. His election was challenged, his seat declared vacant, and his election nullified. His political life turned into a merry-go-round of litigation. And yet, at no point did Dr. Bawumia or his government admit that this was undue pressure that could break a man. So what exactly is his point now? What court challenges, and that court challenges are legitimate when he files them, but illegitimate when his opponents file them? Is that the case? That litigation is a democratic right when the NPP uses it, but persecution when the NDC does? Fellow Ghanaians, this is not only disingenuous, it is dangerous. To demonize court challenges is to undermine the rule of law itself. Ours is supposed to be a country of laws, not of men. If someone believes an election has been conducted irregularly, the Constitution provides a clear path. Go to court. That is not a crime. That is not persecution. That is democracy. To now suggest that seeking judicial redress is somehow illegitimate is to delegitimize the courts, to legitimize the rule of law, and to delegitimize the very principles that underpin our very republic. We must say it clearly. There is nothing wrong with going to court. There is everything wrong with demonizing those who go to court. Fellow Ghanaians, whether in the matter of the Chief Justice, the now removed Chief Justice, Madam Tokono, in the matter of Akotia, the lesson is the same. Our democracy is built on institutions and processes. The Constitution lays out the path. Court exists to resolve disputes. Committees exist to investigate allegations. Elections exist to reflect the will of the people. None of these are perfect. All of them can be abused. But the answer to imperfection is not propaganda. It is not cynicism. It is not demonization. The answer to that is not to insist that the processes not be followed, but to scrutinize them with vigilance and to accept their outcomes with respect. We cannot say the Constitution is supreme only when it removes our opponents and suddenly illegitimate when it touches our allies. We cannot say the courts are noble when they uphold our petitions and suddenly corrupt when they dismiss them. We cannot say elections are credible when we win and suddenly fraudulent when we lose. That is not democracy. That is hypocrisy. And hypocrisy unchecked destroys nations. Fellow Ghanaians, we must be vigilant. We must be principled, and we must defend our Constitution, not with selective outrage, but with consistency. Let us honor our courts, not by demonizing petitions, but by strengthening the rule of law. Let us demand of our politicians that they campaign with ideas, not violence, not bribes, not lies. Because at the end of the day, the Constitution is not a weapon for politicians to wield. It's a shield for citizens to protect their freedoms. The courts are not arenas for partisan demonization. They are sanctuaries for justice, or at least that is what they are supposed to be. And elections are not rituals for vote buying. They are sacred moments for the people's voice to be heard. Fellow Ghanaians, the removal of a Chief Justice may be controversial, but it was constitutional. The by-election in Akotia may be tense, but it must be peaceful. The future of our democracy depends on whether we can separate truth from propaganda, process from paranoia, and duty from opportunism. Let us rise to the challenge, and I wish the people of Akotia all the best as they elect somebody to represent them in Parliament. Good morning, fellow Ghanaians.